皆様こんにちは。ベーカー&マッケンジー法律務所の弁護士の増本と申します。本日は US Litigation Now 3の第5回目といたしまして、米国訴訟における文書開示についてお話をさせていただきます。本日のスピーカーは、弊社ロサンゼルスオフィスパートナーのバリー・トンプソン弁護士です。Hi, Barry. Thank you for joining.
Hi, Mika. It's nice to see you.
We'd like to discuss document production today. So in Japan, we hear a lot about the amount of discovery in US litigation, especially document discovery. Is this overblown or is it a reality?
It is a reality that we are very document intensive in the US in terms of how we do our lawsuits. But the best way to describe it would be to say that the amount of document discovery you will be subjected to as a Japanese company really depends on the complexity of the case that you're involved in, and also the size of the case from a monetary standpoint, and then also how critical the documents are to the litigation itself. The best way to think about that is for smaller cases that you might be involved in, both in terms of the amount in controversy and the issues that you're dealing with, you're likely to be subjected to far less document discovery. The less critical that the documents may be to that case, the less likely they are to be ordered produced by the court. The corollary to that, or the opposite of that, is if you're in a larger case, it's a large amount in controversy with a lot of complex issues, you should expect that the document requests and the demand that you're subjected to in terms of time and cost and money may go up if the other side asks for documents in the right way and goes through the correct procedures. So something for you to keep in mind is that in the US, all forms of discovery, whether they be written questions called interrogatories or document requests themselves, are going to be governed by the issues that are relevant to your case. And so, for example, in California, which is where I live, the scope of discovery, meaning the types of issues that they get to go into, is very, very broad. And it is essentially all documents that are likely to lead to the discovery of some admissible evidence. The documents and things themselves don't actually have to be admissible in the case. They just have to lead to something that might come in the case.
How do courts make the decision to allow or to limit document discovery?
It's primarily done, Mika, based on what we call a balancing test. And that is the court, if asked to make a decision about document requests, it'll balance the burden of the requests themselves to the potential benefit of the person who's being sent the request. And so one way to think about that is, again, as I was saying, if the documents are particularly critical to the case, and the burden or cost of doing so, and effort of doing so, is not going to be particularly great, then that would weigh in favor of imposing the burden of producing the documents. That can mean that even if it's going to be quite expensive for you as a Japanese company, or difficult for you, challenging time-wise and energy-wise to produce documents, you still might have to do it if it's a large case and if the documents are particularly vital to the case. So keep in mind also that you generally have to prove to get documents from the other side that the documents are relevant to the controversy and material, meaning meaningful enough to force you to produce them. So those are really the main considerations. When you are asking someone to produce documents for you, oftentimes the person that's being asked to produce the documents will try to make a showing to the court that it's going to be too burdensome on them to do so. And I think we're going to talk about the type of showing you need to make to the court to avoid a document production or to limit a document production in just a minute. So we'll talk about that then.
Do the parties to a lawsuit ever negotiate over the scope of document requests and document responses?
We do. It's quite common for us to negotiate as part of the process after the document requests are served. So, for example, I may be sitting in my office, I check my email, a set of document requests come in, and I look at them and I say, oh, this is just too overbroad. It's going to be too big of an ask for my client in Japan to provide these documents. I may pick up the phone, or I may write a letter, or I may have a Zoom call similar to this with my opposing counsel, and we do what's called a meet and confer. And in that meet and confer, we will discuss the requests that are being made. We'll discuss the burden that it would be to produce those documents, or even if the documents exist at all. Sometimes they don't, and you just tell the other side that. And then we generally try in these meet and confers to narrow the disputed issues that the parties have over document requests and document responses. We often give a little bit. There's a lot of give and take in a meet and confer process where we try to problem solve and see if we can avoid an official dispute, meaning a motion to compel or what's called a motion for protective order. And oftentimes we're successful at narrowing the disputes or eliminating them entirely. I find that if I have reasonable counsel on the other side and a client that's cooperating with the process, we can oftentimes eliminate those types of disputes and avoid motion practice, which can be quite expensive.
How does the work going before the judge on law and motion matter?
Yeah, so we will have two different ways that we can be in front of the judge. We can end up in front of a judge offensively or defensively. The defensive side of law in motion on document process is often referred to as a motion for protective order, okay? And that comes into play when you get a request from the other side that you think is just too overbroad or is going to cause too much burden for you, or some other reason that maybe it's not relevant material, you think it's just designed to harass you and make things expensive for you. You have the opportunity to first, you go through that meet and confer process with the other side. You try to get them to narrow the requests. And if they agree to do so, that's great. You stop there. And you agree to produce the documents according to how you have narrowed the requests. But if you can't reach agreement and you still believe that the demand, of the request is going to be so great on you that it's just not reasonable under the circumstances, you can go to court on this motion for a protective order. To do that, you need to show the judge, and it's not just you send Barry Thompson in to tell the judge this is going to be time consuming and difficult for us. I would do that for you, of course, but I would need to back it up with some information from the client from Japan saying why exactly it's going to be too demanding and too burdensome. For example, we might say the databases are not stored on our server anymore. They're all on tape, from 20 years ago, and it's going to cost a fortune to get that data. And by the way, the controversy that we have before us really happened long after that. So you shouldn't make me go to backup tapes, spend the time, money, and energy to produce backup tapes. But you would need to show the court that that's the process you would have to go through. And if you do so, courts will oftentimes limit this burdensome type discovery. That's the defensive motion. So that's a motion for protective order. The alternative is where, for example, my client from Japan has sent document requests to the other side. They're very reasonable in scope. They go to issues that are important in the case. And I get responses back from the other side saying they refuse to produce any of it, or when the documents come in, we can tell that they haven't given us all the documents, because it's a partial production, or we know they've left some things out. If that happens, again, we would go through the meet and confer process with the other side. We'd explain why we think they've given us an incomplete production or no production at all. And if they still refuse to provide the documents, we would then file a motion to compel production of documents. We would need to then show the court, again on a motion, by declarations, usually by the lawyers, that the document requests were made, which document requests are in dispute, why we think that we got an incomplete production from the other side, and how they're important to the litigation. And if we make that showing, then the court will probably order those documents produced by the responding side. And that's the offensive, motion that we make. That's called the motion to compel. I will tell you, I've had pretty good luck in my practice of law of not having to file that many motions for protective order or motions to compel, because I always try as much as I can to stake out very reasonable positions for my clients, because in the end, most of the time, the judge will require that. They'll require a very reasonable approach from both sides. And it just costs a lot of money if you don't stake out a reasonable position. So I think by and large, you can eliminate these disputes by sort of having good counsel and by, taking reasonable positions.
Mechanically, what is the step in the process for document discovery?
Okay, good question. So the first step, obviously, is you have to send a written document, document requests, listing each request you want, each type of documents or category of documents you want. You can do this under state rules or under federal rules, and they have slightly different time periods for the other side to respond. Usually, after you send them, about 20 or 30 days later, the other side has to provide you a written response. That's the next step, where they object and respond to your requests. And they may raise legal objections, like saying it calls for privileged material, or they may say it's overbroad and burdensome and oppressive, things of that nature. They have to write it out for each request. And then they also are supposed to tell you, and this is where sometimes the process breaks down, they're supposed to tell you if they are not providing documents in response to each request, right? Are they just objecting, or are they objecting but then saying what we call, without waiving these objections, we agree to produce the following documents or the following categories of documents, okay? That's important. If I'm the one sending the document request, I now know what the fight is about. I know, okay, I sent this first request and I asked from all of their financial statements for the year 2022. And they've said, objection, burdensome and oppressive, we refuse to produce those documents, right? Now I know I have a dispute that I need to meet and confer over, all right? And usually that third step in the process is the meet and confer process. And that takes place about a week to 10 days, maybe 2 weeks after you get the document, the written document back saying we're objecting, but we may respond or may give you documents on each request, okay? So that's step 3. If that meet and confer process fails, so step 3 failed, we move on to step 4, where now we are either, the responding party is either filing a motion for protective order, explaining that this is too burdensome or difficult for us to produce these things, or the party who propounded the requests for documents is saying, you haven't given me everything I'm entitled to. I'm filing a motion to compel against you, and I'm going to show the judge why these requests are proper, why they're proper in scope, and that I've met and conferred over this, and you're still refusing to produce, important documents for the litigation. Okay? That, if there is no motion to compel, and if there is no motion for protective order, the party who received the document request should now be collecting the documents, all right? And they should be then screening them for responsiveness, and they should there's a long process that I think you and I are going to talk about in just a minute that we can go through in a little more detail. But the bottom line is if they don't object to the requests and they agree to produce certain documents, the next step they should do should be they produce the documents. They actually give you the documents that you've requested. So that's kind of our process for document discovery.
What are the typical steps in the document identification and production process?
Okay. This, Mika, I'm sure we could do a whole nother video series on this process, because the document identification and document production process is extremely involved. And it's very important that you get it right, because there are repercussions if you don't get it right. So let me kind of tell you what the general process is. Again, keeping in mind that we could talk for an hour or two about this if we had the time. So the first part of it is you as the person that receives the requests need to identify certain categories of documents and or quote unquote custodial files might have documents that are responsive. And when I say custodial files, so for example, you and I and Akira-san work together on different litigation matters. You keep a custodial file on the litigation matters that you and I work on. Akira-san does as well. I do as well. You, Mika-san, would be a custodian of litigation documents. Akira-san would be, and so would Barry-san. All right. And so we have to identify the people who have information or potentially documents relevant to the controversy and consider pulling their documents electronically into this document identification process. You and I have done that a number of times together in our litigations with Akira-san. So that's the first thing, identifying the custodial files and the categories of documents. Next thing to do is you really need to set up an outside counsel document review protocol. That means you need to set up the categories of documents that are being requested by the other side, and you need to start doing searches of your documents. Now you can do this manually, having people individually going through all the documents to look for the responsive documents, but that's incredibly expensive and we don't recommend that. The better course is you run searches based on search terms, or to use technology-assisted review, which is an AI-like tool to help you pull those documents and cull those documents out. Ultimately, you're going to need counsel, your outside counsel, to be involved in this process to do a final review for the truly responsive documents, because you don't want to give up any documents that are privileged to the other side, and you don't want your document production to be too broad. Okay, so that's that responsiveness look, and then sometimes when we do that review for responsiveness, or we use the AI tool, it's called TAR, or Targeted Assisted Review. We will code the documents by issue at the same time, so that we know what issues are being discussed in the documents, and we can then prepare our witnesses with those documents and be prepared to use them offensively and defensively, the documents, so we know our documents as well as possible. And then finally, if the documents, once the documents have been vetted in this process, you will identify them, you'll process them, and you will number them and then produce them to the other side electronically. That's the most common process we use now. In the olden days, we did it all by hand. We would punch them with a stamp. Each one had a different, number. No, that's not how it's done anymore. Everything's essentially electronic at this point, as it should be.
Once the party produces its documents, is that the end of their obligations?
It would seem like it should be, right? And to a certain extent, the answer is, I'm going to give you a yes and no answer. The answer is, once the client reviews the documents, produces the documents in response to requests, for the moment, you are done with your obligations for document production, all right, the responsive part. However, in some jurisdictions, like in federal court in the US, you have what's called a continuing obligation to produce documents, meaning you have to, at certain periods or intervals, you have to supplement your production of documents if new documents are being created or generated that respond or are responsive to the original requests. So you just have to keep that in mind. Now, keep in mind, the reason it's important to do a very fulsome document production is you might need these documents in your trial or in your arbitration. And if the other side has asked for these documents and you failed to produce them, even the documents that come after the production request, if in a jurisdiction where you have a continuing duty to supplement your production, if you don't supplement with those documents, the court or tribunal will probably bar you from using the documents. And so particularly if they're helpful documents, you've got to find a way to get them out to the other side, because you don't want to lose your ability to act offensively with your own documents.
If a Japanese company is sued in the US, can the company run the searches for the documents and send them to its lawyers?
Generally, it is a collaborative process. I mean, as you and I know, you're across the big pond from us in California, the big ocean, and you and Akira-san have to be involved in the process in Japan of working with the company to gather and collect the documents to help us identify the custodians, etc. But it is more or less mandatory that your outside counsel is directing the process. And by that, I mean, most courts in the US will not be happy to have the plaintiff or defendant in the lawsuit, company in Japan, run the whole process all by itself. And that, not to suggest that anyone, intentionally is doing anything wrong, and that's why, they're not allowed to do it all alone without their outside counsel. But there is some concern about the fact that, if you have an interest in the litigation, you might not select certain documents to be part of the process. And so the courts in the US, let's just say they're much more comfortable if outside counsel is heavily involved in that process of vetting the documents. And then ultimately there have to be a lot of strategic calls made along with your outside counsel about what documents are actually responsive to the requests. And so I would say it's better done. The best practice is to have the Japanese company working with its outside counsel and have the final decisions on responsiveness of documents, and also legal privilege, for example, done by your outside counsel.
What are the potential pitfalls or consequences if proper procedures are not followed by the responding party?
Okay. Very good question and very important. So imagine that a company fails to put a document hold in place before, when it's pretty obvious that litigation is about to happen against that company. So Japanese company A, gets a letter from a lawyer saying, we're going to sue you if you don't do this. And the company realizes that there's a potential problem here, but doesn't put a litigation hold in place to preserve its documents. Okay, that's one example. Or imagine that the company has a document destruction policy in place where it just routinely every 30 days just cleans out all its electronic documents, and those documents are not saved anywhere else, for later use. So that could be done accidentally. And then sometimes in very rare circumstances, and I've never seen it in Japan, but in very rare circumstances, sometimes people actually do destroy the documents that they know are bad documents. Okay, that's another example. Or maybe the company in Japan doesn't fully respond to the document request. It leaves a few important custodians off because it just isn't sure if they're important enough, or accidentally leaves some documents out. And so its production of documents was incomplete. Okay. Any of those are possible scenarios where a court, if the Japanese company is brought before the court on a motion to compel, might decide that there's been some type of abuse in the discovery process. And it might decide, it has a lot of fairly serious things that can be done in that litigation if it makes such a finding. For example, the court could award monetary sanctions for, a failure in this discovery process from a document standpoint. They could order you to pay $5,000 US or $50,000 US. It's supposed to be, the sanction is supposed to be in line with the infraction or the error that was made, but that's an option. Another option is they can, and this one's a big problem. The next two are the big problems. The court, if it finds that documents were either hidden or destroyed, can tell the jury that the jury can assume that the reason the documents were hidden or destroyed is because they would have been adverse to the company, meaning they would have said bad things about you and the way what you were doing. And they may say that and not even allow you to dispute the issue, okay? Which is a big deal. If I'm going to trial for you and I have an adverse inference saying the jury should assume your documents are bad and against your interests, that's tough for me to overcome. I mean, I'll keep fighting, but it'll be tough for me. And then the last thing they can do, which is the most severe and rarely happens but can happen, is, when we file a complaint, right, for money damages or some type of relief, the opposing side files an answer to that. And if there's real document discovery abuse, a court can decide that it's so severe, it will strike your complaint, meaning all of your claims would be dismissed, or it can strike your answer and just enter judgment against you. And it will only be about what the damages are against you. And so these are really, there are very serious consequences in the document discovery process if you don't take it with absolute and utter seriousness. And frankly, if you don't get really good advice from your outside lawyers how to protect yourself from these things. So, our advice is take document discovery very seriously and make sure you're well represented. And you should do fine in the US courts. I've had such great experience representing Japanese companies in the US courts. And I'm quite confident that with this understanding that we've talked about now over the last, I think, 15 or 20 minutes, Japanese companies are ready to go and will do quite well in US litigation.
Thank you, Vari, for your comprehensive explanation about document production.
My pleasure, Mika, and I hope it was helpful.
本日は米国訴訟における文書開示に関し、その範囲や具体的なプロセスについてご説明をさせていただきました。US Litigation Now 3では今後も引き続き米国訴訟の手続きや最新のトピックについてご説明をさせていただきたいと考えております。今後も本ビデオシリーズをお楽しみにしていただければ幸いです。本日はご視聴いただきましてありがとうございました。